I have the privilege of introducing to you Tando Mbono, who was with us at the beginning of the sessions. He's a manager in the Retirement Funds Supervision Department, our division rather, and he'll be talking on the protection of retirement benefits and the extent to which the retirement benefits are protected. Over to you, Tando.
Okay, thanks, Julia, and good morning, everybody. I'm gonna try and keep it tight. It's a fairly few number of slides for purposes of just allowing for questions at the end, so that the workshop can mark my homework at the end of the presentation. So, without wasting any more time, can we go to the first slide, Sanchia, please? So by way of introduction, we all know that pension benefits have a social purpose, social security purpose, which they serve, and in that spirit, the legislature has afforded it special protections in terms of Section 37A of the Act, which prevents it from being reduced and hypothecated, and all sorts of things. So I'm going to be presenting to you, just having reference to the table of contents, the protection of benefits and the exceptions that are provided for in Section 37A, 1, and the permissible deductions and the effects of sequestration on pension benefits. So what we're going to do, we're not going to delve much into, or at all, as a matter of fact, into maintenance orders and divorce orders and housing loans and those sorts of things. As Sanchia has already said, those have a presentation entirely of their own. So I'm just going to be touching on specifically on Section 37D deductions when it comes to permissible deductions, which I think is a burning issue, which I think it's an issue that merits some in-depth consideration and allow trustees to ask questions at the end of the session. Then we're going to move on to the sequestration implications on pension benefits. So if you could just page for me, Sanchia. So this is under Section 37A1, ladies and gentlemen. So what I've decided to do is to show you the people against whom pension benefits are protected, at least the people that may be inclined either to encumber them or to reduce them or to attach and all of those things. Because those prohibitions that the Act says may not happen in respect of pension benefits are not applicable to every single person or stakeholder in the fund, like the fund, like the member, like third parties, for instance. So specific encumbrances are related and are specific to a certain stakeholder within the fund. So at the outset, the Act says pension benefits may not be transferred. Obviously, save for the permissible deductions that I've just said, I will exclude from the presentation. So at the outset, it prohibits the transfer, the cession, the hypothec, the pledge, and the set of pension benefits. And these are what you will call limited real security rights. This is a class of limited real security rights in terms of which the member may transfer his claim to a benefit or a benefit to a third party against the fund in securing a debt, for instance, that the member would be indebted to as against a creditor. So what I would like to do, ladies and gentlemen, I wouldn't delve into each and every specific one of them because these are very complicated limited real rights that have many different permutations, which would not serve the purpose of this presentation. But I just wanted to show you their nature, what they are, that they are limited real security rights, which allow a member, or at least a property owner of any sort, but the Act specifically prohibits a member to deal with them in the ordinary manner that an owner would deal with his property. So that we have an idea, for instance, of what may happen in the case where a member is pledging a benefit or transferring a benefit or hypothecating a benefit or some such endeavor. So, and I'll just give you an example, for instance, so that you have a picture of how in practice this would happen. If, for instance, a member is asking for a loan, for instance, from a financier, let's say, against the pension benefit and uses that pension benefit or proposes to use that pension benefit as security. So what do? You go to a loan shark or a financier, a reputable financier, and then you say to them, you're looking for a loan, say, of 500,000 Rand, and you show them your benefit statement, and they see that you are good for the 500,000 Rand. You tell them that I'm retiring or I'm withdrawing from the fund, I'm resigning in the next 6 months, for instance, and you would like a loan. You pay installments, and then should you default on the loan, then you sign an agreement in terms of which you allow your creditor to enforce its claim against the fund when it becomes due, the benefit becomes due or it accrues to you, and then you transfer that right to claim to a third party, being your creditor. That is what these things contemplate in the ordinary course. But what the Act says is that a member may not do that to transfer the ownership to a party that may enforce that right against a third party. So Section 37A is aimed exactly at that mischief, to prevent the mischief from happening of members using benefits as securities. So in this example, what the section continues to say is that board members have a discretion upon becoming aware that such an attempt has been made. They then have a discretion to suspend the payment of the benefit to the member when it falls due. They have a discretion to withhold the benefit, or alternatively pay a part of it or all of it to a dependent or a beneficiary or a trust in favor of the dependents of the member. That is when they become aware that such an attempt has been made. So I just want to give you another example that would distinguish the first example that I have given you, that does not attach or attract the same consequences such as I have just outlined, so that you can see that there's a distinction between a member wanting or undertaking to use a benefit in a particular way and a member actually pledging his benefit in favor of a creditor. So members of this fund, for instance, decide in their minds that they would like to withdraw from the fund and get their benefits while they are still employed. They don't want to terminate employment, but they want to be paid out their benefits while they are still employed. So they think it's a good idea. They approach an attorney. The attorney tells them it is doable. They can do it. But they need to sign a contingency agreement in terms of which, if he succeeds in getting the money from the fund and paying and having the money paid to them, then he will be entitled to 25%, or they will use 25% of the benefit to pay for his fees. Otherwise, he's going to do the work for free now until he succeeds in doing what he wants, what they want, and then they're gonna pay him from their benefit. So all is agreed, and members sign this agreement, and the attorney goes to work. Obviously, it is obvious, as you know, that idea is dead on arrival. It's something that cannot happen. But the principle that I'm trying to illustrate here, I'm trying to contrast a situation where members undertake to do something with money when it gets into their account. as opposed to when they where they transfer their entitlement to the benefit to the creditor, who will exercise the right that the member would otherwise have exercised had the member not bound himself to the creditor. So the court said in this case that is not prohibited under Section 37A of the Act. And that matter was decided in the case of Smith versus Smith and another, that as long as you are not transferring your claim and imbuing the creditor with the ability to enforce the benefit against the fund, then you are fine, because the benefit is protected in the hands of the fund. It is not protected in the hands of the member. In other words, when a benefit is paid to a member, it is no longer a pension benefit. It is money. It forms part of your estate. So you do not have the protection of Section 37A once the money is paid to you. So whatever you undertake to do upon receipt of that money is not hit by Section 37A. So that's what the court said in Smith versus Smith and another. So in that example of the attorney, I was at first blush, I thought that they were in violation of 37A until I realized that this fine distinction that I've just made reference to. So that is the case that appears on your screen right at the bottom. That is the dictum of the court in Smith versus Smith, where the husband had declined to honor the settlement agreement in a divorce, in terms of which he had undertaken to pay 50% of the benefit to his wife upon divorce. And the husband took the position that that agreement in the first place was in violation of Section 37A, and the court said no, not so. So let's proceed, Sanchia. Sanchia, are you with me? All right. So that is what I've just said, that there is an obligation on the board to deter such practices, so that upon becoming aware that members have tried to hypothecate or to pledge or to cede their benefits, then the board has a discretion to not pay or withhold, but only in circumstances where this amounts to a transfer, as opposed to a mere undertaking that this is what I'm going to do, this is what I'm going to pay once I am paid my benefit. Let's proceed, Sanchia. Is your thing jammed? All right. While we wait for Sanchia to page, now let's look at what. So in other words, those are the prohibitions that apply only in relation to a member. Now let's look at what it means in relation to a fund, what a fund may not do in relation to a benefit. So the Act says a fund may not reduce a benefit to a member. And it is only the fund that can reduce a benefit, because for practical purposes, it is the fund that is in possession of or has authority over the benefit. So only it can make a deduction by way of a reduction, for instance, of the member's benefit. So how does that happen? If Section 37A, I think sub 2, defines a reduction as the residue of a member's benefit that he ultimately gets after a debt that is owed to his creditor has been deducted, save of course for the permissible deductions. So if the member retires or withdraws with less than that which the rules provide for, and in terms of the computation of the benefit, because a deduction has been made in favor of a debtor, then that amounts to a deduction. And also some commentators say, as a matter of fact, when in our example, for instance, with a creditor, if a creditor submits this document to the fund and the fund accedes to that and pays out the money to the creditor in contravention of 37A, then that payment will constitute a reduction of the benefit. So the benefit will have been reduced, and thereby contravening the provision that says they may not be reduced. Another way which I think most of you will be familiar with is in terms of amendment of the rules, where the computation of the benefit is the multiples in terms of which the benefit is computed, for instance, are amended to provide for a lesser benefit, then that's a reduction of a benefit. And the court said, where I think it is in Grobler, a joint municipality pension fund versus Grobler, where a benefit has already accrued to the member. That is, by accrual, we mean it is the trigger event that is conditional upon which the benefit is payable has happened. So the benefit is accrued, or the right to the benefit is accrued. Then it is too late to amend your rules to reduce the benefit, because you will be in contravention of section 37A. But obviously, the court said, where it is a prospective reduction of the manner in which benefits are computed, in that case, you are fine. But I'm sure you are aware of the decision of the FSCA, which has done a 180-degree turn on that time-honored principle, or law, as a matter of fact, because they had said it as law that this is what happens. So the court recently in Modao versus, or MEPF versus Modao, the court said, actually, no, you cannot limit a fund on how it wants to compute its benefits, even if they have accrued, if they do so by way of a rule amendment, and that rule amendment is retrospective to a date preceding the one during which the benefit had accrued to the member. So it seems that the law is a little bit unsettled, because that's the last word that has been spoken on this issue. And I'm not aware if Modawi is appealing the decision or is not appealing the decision, but I know it has upset the apple cart, and many commentators in the industry have criticized it. But perhaps for purposes of this discussion, I just wanted to make you aware that the position that I was conversing with you was valid up to the decision of Modao, at least to the extent that it deals with a reduction of benefits by the employer. And then lastly, against third parties, the Act prohibits the attachment of a benefit by a creditor of the fund. So you may not execute against a benefit, you may not attach a benefit, even if you have a court order and the member owes you. The Act is dead against that. That may not be done by third parties. So those are the protections that are afforded to members, or to members' benefits, because it protects even against them, members against themselves, and against the fund, and against the third parties. But lastly, it also prohibits the set off of a benefit by the fund. A set off can only be done by the fund, because it is the fund that is in possession of the benefit. So what a set off is not a reduction, sorry, per se. It is just a discharge of obligations, or a termination of obligations between people who are indebted to each other, and their claims against each other cancel each other out. for instance. In other words, for an example, if you have a member that resigns from the fund and he gets his benefit, and for some reason he is overpaid, okay? Is overpaid by the fund, and the fund calls the member, he wants to recoup the benefit, and the member doesn't blink. And it happens, let's say for example, it happens that there's money that comes into the fund. Say a transfer in value from another fund that was never transferred for some reason. The fund is in possession of this money, say 200,000 rand, in circumstances where the member was paid an extra 100,000 rand by mistake. So if the fund intends to set off, in other words, to deduct the money that is owed by the member to it and send the difference to the member, the Act says no, that cannot be done. That cannot be done, and the adjudicator was very emphatic against Sanlam on that proposition, that even if you have overpaid a member, once you try to recoup from him by way of taking a portion of his benefit that he may be entitled to subsequently, you are setting off that right, that debt against what he owes you, and that cannot be done. The Act is dead against that. Obviously, you have an enrichment action against the member because he's been unjustifiably enriched, admittedly, against the fund, but you may not resort to reducing his benefit, even if you wanted to. So those are the protections that ladies and gentlemen, Section 37A confers on members. I'm not sure, Sanchia, if we are now on the right slide, because I saw it flashing up and down for a moment. But let's proceed then to deductions that are in fact permissible. The limited deductions that are permissible that the fund may make against the benefit as a departure from the general proposition. All right. So Section 37D, sub 1B, Roman 2 of the Act says a registered fund may deduct any amount due by a member to his employer on the date of his retirement or on which he ceases to be a member of the fund in respect of compensation, including any legal costs recoverable from the member in a matter contemplated in subparagraph PB, in respect of any damage caused to the employer by reason of any theft, dishonesty, fraud, or misconduct by the member, and in respect of which the member has in writing admitted liability to the employer, or judgment has been obtained against the member in any court, including a magistrate's court, from any benefit payable in respect of the member or beneficiary in terms of the rules of the fund, and pay such amount to the employer concerned. So as you know, ladies and gentlemen, this is one of the highly contested areas of our law. And for reasons that we already canvassed earlier when we spoke in the first session, that there is an inclination towards employers to weaponize the withholding or reduction of benefits as a result of fraud, and this practice is much prevalent, and the adjudicator has done a lot of work against such practices. The FSCA is also dead against that practice, and the courts, if you read the decisions that have been coming from the courts, you realize that it has a special wrath for employers and funds who behave in this manner. So I want to just spend a bit of time with you and just set out the requirements that have to be met where a member is accused of having caused damages to a fund. To an employer, and what the obligations of the employer, of the fund are in that regard. So the first question is, what sort of misconduct does the Act contemplate in respect of which there may be a deduction? from a member or a reduction of a member's benefit. So the X's, there must be dishonesty, there must be a fraud, there must be theft or misconduct. That's the first leg that you have to consider. And the second leg is that such misconduct, fraud, theft, or dishonesty has caused loss to the employer, financial loss to the employer. So that is the test. But then you have to examine these forms of prescriptions that the court says or the act says must exist to check whether the conduct of the member fit within the four corners of those. Fraud is obvious. We all know fraud. Theft is obvious. Dishonesty is obvious. But what bears perhaps some clarification is misconduct, because misconduct is a creature of the Labor Relations Act, as you know, and it's in the disciplinary code of the employer, and it may be anything that is conduct that is actionable by the employer against employees, anything that within the parameters of the LRA. But the misconduct that we're talking about here is not any form of misconduct. In other words, if an employer or an employee causes loss to an employer, say for instance by losing a laptop, crashing a company car, and that sort of misconduct, if it's shown to be negligent, that is not the misconduct that we contemplate here, because it does not have the element of dishonesty. So the courts have defined misconduct narrowly to refer to one which comprises an element of dishonesty. And that interpretation is contextualized by the other prescriptions that go before that, like the misconduct, sorry, the fraud, the theft, and the dishonesty. So the canon of interpretation there is that because those words are specific and are narrow in meaning, then they are imputed, their meaning is imputed on the misconduct. So you narrow it down. So that is what you are dealing with as far as the conduct of the employer, of the employee rather. Then you have to consider whether the employer has suffered damages, as causal damages flowing from the conduct of the employee. If yes, then you've got your elements. So the employer comes to you, he requests a withholding of the benefit as opposed to a reduction, because first of all, the employer must first have a judgment against the member or an admission of liability against the member before a reduction of the benefit can be made. And it is in very rare circumstances that a member would admit to that, and you would not have to get a court order for you to be able to reduce. So more often than not, you'll find yourself having to go to court to obtain a judgment which must say you are entitled to your damages and you are entitled to reduce against the member's benefit. So when you receive that document, and withholding, you gentlemen and ladies already know that withholding has been interpreted to mean contextually or reduction must include withholding for practical purposes, because if you are running to court, the member is resigning, being dissipated. So the whole effort is fruitless. So you have to withhold the benefit, at least while the employer is pursuing proceedings. Civil proceedings, might I emphasize, against the member. So the board receives this request from the employer, and what must the board look for? I've already set out the elements that must meet with the conduct of the employer. But then the courts have said, and I've cited the decision here. I think it will show below, that there is an obligation on the fund in terms of the rules of natural justice to hear out the version of the member. What does the member say about the allegation, because these things can be trumped up sometimes. So you hear the allegation of the employer, then you take representations of the member, and then you weigh you exercise your discretion, having had the version of the employer and having had the version of the member. So what you look at there when you are confronted with this is you look at whether or not how long the proceedings may reasonably take to be finalized, what are the personal circumstances of the member, and how much is owed or allegedly owed by the member to the employer. So all of those considerations must go into your scales, because it often happens that members' monies are withheld in excess of what they are actually accused of stealing from the employer, as happened in the matter of SA Metal Group versus Jefta, that the amount that was being withheld was at least in excess by 300,000 rand, which he could have used in the intervening period between the resignation and the finalization of the proceedings. But the board did not apply its mind. The board cowered to the whims of the employer and withhold this money into infinity, not hearing the version of the member and all of that. And ladies and gentlemen, the fund and the employer came for some very serious judicial reprimand. They were castigated. The court mopped the floor with them. And that is not in keeping with the duty of loyalty that board members owe to funds. Because once your fund is in the law reports, reflected in the most unflattering light as being maladministered and those sorts of things, you're already in violation of your duty to your fund, to the members, and to the employers who are stakeholders in the fund, because sometimes it is not always the case that employers are lying. We know that the things such as corruption and fraud are rife in this town. So it is not always a far-fetched idea that an employee has embezzled money from the employer. But you have that balancing act as a board member. It's a job that you have. It's an enviable job because of the considerations that you have to put on the scales. But it is for this purpose that we have such workshops, so that we canvass these issues and you are alive to them before you see your fund's name on the law reports, because once it is there, it is never coming. So there be very vigilant, and I'm very privileged to be able to say that from the bully pulpit of the regulator. But it is for a good reason, so that boards are administered properly to the benefit of all that are stakeholders in them. So that is what happens in respect of a 37D withholding. One aspect that I may have missed perhaps is when, in the rare instance that you would have an admission from an employee that they in fact stole the money, that admission has to be of a certain quality, and that the first adjudicator said it must be unequivocal in its terms. In other words, there must be no doubt that this is an admission of liability, and the amounts to which the member is admitting must be consistent with the amounts that are alleged to have been stolen. There should be no discrepancy, because if he admits less than is claimed, then the difference there is not capable of being withheld, especially in the absence of a court order to that effect. And another thing that the FST I think has disabused us of was the idea that criminal proceedings will suffice for want of a civil judgment against the member. So the FST said no, not so. Criminal proceedings and a civil judgment are not the same thing. So you may not withhold the benefit because if an employer says, I've gone to the police station, here's the name of the sergeant, and here's a case number, and that sort of thing, because he said they're just fundamentally different. Because the Act because the Act grants the employer to reduce the amount that is being stolen from it and the cost of the litigation that it embarked on. So when you get a conviction as a criminal, outcome, you do not get to pay costs. You just go to jail. So that's not comparable. The adjudicator said. So I think the idea should be retired that members' monies can be withheld because the employer says it's going to the police station and is waiting for a case number and some such things. So yeah, let's proceed, Sanchia. So lastly, ladies and gentlemen, we are concerned with the effect of sequestration on pension benefits. Now, sequestration is obviously when a member is insolvent and his assets are less than his liabilities, is unable to pay his debts when they fall due, and his creditors take him to court to sequestrate him, and he'll be declared an insolvent, which is the legal status. Obviously, you may be factually insolvent, but before you are finally sequestrated, the court has pronounced as such, then that section does not hit you. So what this section says is that, remember, we have spoken earlier about how Section 37A protects benefits in the hands of the fund, which must be emphasized, that it is in the hands of the fund. In other words, the fund may not be sued. The fund may not, and no claim may succeed against the fund in pursuance of a security that the creditor purports to have. That protection is in the hands of the fund. But here is different. Under circumstances of sequestration, the court says, sorry, the Act says, when you are sequestrated, your benefit that you are entitled to from a pension fund does not form part of your assets in your sequestrated estate. So it is beyond the reach of your trustee. It is beyond the reach of your creditors. You may enjoy it because it is protected under Section 37B. That protection extends right into the hands of the member, as opposed to the earlier position that I've just outlined. So what happens here in this case, in Mr. Mora's case, versus, I'll show you the citation just below, versus his creditors. Mr. Mora was indebted to these creditors, and it appears that he knew that under the Act, he is not, yes, I'm not sure if I'm pronouncing it correctly, ladies and gentlemen, you'll excuse me if I'm not pronouncing it correctly, but it's more, as I read it, it's Mora and another versus Murray and others. So what had happened is that he owed money to creditors. They wanted to sequestrate him, and what he did, he tried to scam them. He went and got his pension benefit from the fund after the creditors have filed claims and all of those things. He went and got his pension benefit of about 5 million rand, and he started dissipating it in collusion with his wife, paying the wife, divorcing the wife under false pretenses, and going on a shopping spree. He bought farms, he bought houses, he bought all of those things. And then it hit home. The creditors came for all these monies that were paid to these people and the farms that were bought with the money. And the creditors said, these are avoidable dispositions. They are calculated to defraud the creditors. Therefore, they must be reversed. So our friend Mr. Mora raised the defense and said Section 37B provides that a benefit in the insolvent estate does not form part of his assets. So they are protected. His money is protected, and the process thereof are protected. And the court said not so fast. The court said, and this is important, the court said that provision applies to a person's estate who has been sequestrated, finally sequestrated, and has been declared insolvent by an order of court. Mr. Mora got his money from the fund, withdrew before he was finally sequestrated, before he was sequestrated even. There was no trustee appointed. The sequestration had not been done or finalized. So the court said, then you are not, you cannot bring yourself within the protection of 37B because you were not sequestrated at the time. And that is the requirement for sequestration. And then he was out. And because he couldn't meet that requirement that he must be sequestrated for his assets to be protected from the clutches of the creditors. So what he did and his counsel did, they then resorted to Section 37A in the alternative. And they said, under Section 37A, a benefit that is payable to a member is not capable of being reduced or attached, for that matter, as we have discussed. But then the court said not so. The matter turned on the definition of a benefit. And the definition of a benefit says a benefit is money that is payable. The emphasis here is on payable. Is payable to a member, not paid. Mr. Mura, you were paid. The money was not payable. So the money was protected while it was still payable, as we discussed, in the hands of the fund. But once it was paid to you, it loses its character as a benefit. It is no longer a benefit, it is money. You can dispose of it howsoever you choose. So 37A does not avail you any protection. So Mr. Mora was out on both provisions, 37A and 37B, which protects benefits that are under sequestration of persons who are sequestrated. Sorry. So that is it, ladies and gentlemen. Perhaps if I can just squeeze in just two things that are also exemptions from the reduction, which is our insurance claims and pension, medical aid contributions, which are also by arrangement between the fund and the member, may be deducted from the member's benefit if there is an agreement, but it must be money that is owed to the fund. In cases where the adjudicator said this is not compliant, it's because employers had advanced members for purposes of paying premiums and medical aid benefits. So the adjudicator said no. The language of the provision is that it must be money owed, and there must be a prior arrangement, and by written consent of the registrar. So that is it as far as protection of benefits under Section 37A are concerned. Thank you, Julia. And ladies and gentlemen, thank you.
Thank you so much, Tando, for such an insightful presentation. And before I start with my questions, there's a question in the comment section from Jeanette Zengele. I hope I'm pronouncing that correctly. And she says, what about a member that gives 24 hours notice to the employer in cases where they never returned assigned liability to the employer? What happens? And my understanding is that this member served notice, but they haven't signed the admission of liability. And I'm assuming that if you look at section 37D1B, 2, it provides for the admission of liability, or the employer can then obtain a court judgment to get whatever is owed to him from the benefit of a member. So there are other avenues that the employer can explore. And I'm not sure if you want to add on that point.
Not yet, right? I think you're on it, Julia, because at the end of the day, you give 24 months, 24-hour notice to the employer, but the benefit is still with the fund. And remember, we said it is the fund that can reduce the benefit. So all that is needs to happen is for the employer, because the option of admission of liability is already out of the window. So the employer will go to court and get a judgment. Obviously, you will still be required as a fund to hear the representations of the member who ran away and hear what the story was there. But I think the answer is correct.
All right, thank you. And there's a question from Sheila Changa, and she's asking, what is the member absconded? Can you take that, Tando?
What if the member absconded?
Yeah, I'm not sure if she's saying what if. Sheila, I'm not sure if you're able to ask this question. Sanchia, can you assist in unmuting Sheila Changa, if possible? Tando, there's a question here regarding the Smith case, and Nahim Esop is asking, is your understanding of the Smith case that an undertaking can only be given after the member has received his benefit? If not, what is the difference between the prohibition on transfer and seed as it appears in section 37A and an undertaking as it is referred to in the Smith case?
Okay, thanks, Julia. That's a very good question, and I grappled with it for a while. Like I said, I was also under the impression that those attorneys and those members were in contravention of 37A. But my understanding of the Smith case is that the settlement agreement between the husband and wife was signed, and the undertaking was made in advance that when I get the money, I will pay you. And then the defense of section 37A was raised later when the wife came to enforce the agreement. All right. So and he raised the defense in 37A. And in my understanding, it turns on what the judge said, that because Mr. Smith is not conferring on the wife the competence or a right of claim against the fund for the 50%. He merely is undertaking to pay from his pocket the 50% after it has been paid. Therefore, it does not fall foul of section 37A. Whereas in the case of a pledge, you actually transfer the right of claim. In other words, the creditor can go directly to the fund and claim and enforce it against the fund, because the fund would otherwise be bound, which is what the difference is in the Smith case, in my understanding of it. I'm not sure if I'm answering Nahim. Thank you, Julia.
Thank you so much, Tando. Nahim, are you happy with the answer? Okay, thank you so much, Tando. I think that sufficiently answers his question. There's a question from Sheila. She has clarified that what if the member has gone into hiding and cannot be found? And I'm assuming that the employer then cannot get the admission of liability, and then there's this benefit of this particular member in the fund. So just to answer the question, Sheila, I would then ask, does the employer have got details of the member? And obviously they do, and the fund rather have details of the member, they do, and they can't trace the member, and the member, because the member has absconded. What is the reason for absconding? So now, Tando, you have this benefit of a member in this fund, in this particular fund, that is due to this member. What happens to it if they cannot find the member? The employer still needs to get paid. Is there anything that the fund can do, or the employer can do in this instance to get what is due to him?
All right. So if the member cannot be found, it means it cannot be found for all intents and purposes. The benefit will still remain in the fund. All right. And the employer may institute proceedings. Obviously, the rules of court make provision for how you make service to a person, for instance, of the nature of the member, or guilt or default judgment, whatever, against the member, where you cannot find them. Obviously, you will have to show to court that you have attempted service and all else fails, or whatever. The people who practice civil litigation will tell you. But in the end, there will be no harm to the fund, because the benefit will still be there. And all that the fund needs to look at when the employer comes back is that, do you have a court order? It is the business of the employer how they litigate against a person they cannot find. But obviously, the issue of admission of liability is out of the window, because you cannot admit when you cannot be found. When the employer walks through the door, he must present an admission of liability, because at any rate, that the employee has absconded and cannot be found will still be on the version of the employer. So as long as he does not have that, in my view, there is no reduction that is permissible against the member's benefit.
Okay, thank you so much, Tando. I think that answers Sheila's question, that the employer can then produce the court judgment to the fund in order to claim what belongs to, or what is due to him. There's a question from Morgan Mtembu. Is my understanding correct that in the absence of sequestration, as soon as the benefit is paid to the member, all the other legal protection ceases to apply? So in the absence of sequestration, so the member is not yet sequestrated and the benefit is, so is the benefit still in the fund, or is the benefit paid to the member? Is it in the hands of, I think Tando elaborated on this in the presentation, is the benefit in the hands of the member or in the hands of the employer? I think that will be my question to you, Morgan. Tando, do you want to take this?
Yeah, the authorities are very clear that a benefit is not a benefit once it leaves the fund and it gets into your account. It loses its character as a benefit. It is something else. And if you are not sequestrated, it forms part of your estate and can be attached by your creditors in your hands. So long after 37A has left the room. That will be all. Thank you, Julia.
All right, thank you, Tando. Tando, there is, when you spoke about that the fund should consider the time it will take for the judgment or the proceedings to be finalized, is there a reasonable period within which the fund can hold a member's benefit, or does it depend on the outcome of the judgment? And also, you find in some instances a fund is holding a member's benefit for around 5, 6, 3 years. Is there a reasonable period within which they can withhold a benefit?
All right. The test, Julia, is, perhaps I must emphasize, is what is the employer doing about moving the matter forward? In other words, how court process moves is not in the hands of the employer, but the board has to be satisfied that reasonable effort has been made on the part of the employer to prosecute the claim. If summons have been issued and process has been served and all of that, then it is reasonable for the board to assume that this matter is being diligently pursued, other than where there is nothing. For instance, in another case, I think the adjudicator dealt with a matter where they were supposed to go and institute proceedings, and they came back after a year with a legal opinion that the member does not have capacity to relinquish or to contract and that sort of thing. And the adjudicator said, I have given you enough time, and you're coming back here and you're telling me stuff that does not make sense. So it is the reasonableness is not so much on the time per se, but the effort that is put in prosecuting the matter.
Okay, thank you so much. I think that is also related to a question that was posed by Gareth Evans, where he's asking, what is the situation where a civil court case date is far in the future due to the pressure of the courts? Can the trustees agree to withhold pension benefits in this time? And like I said, in section 37D, there are other avenues. So while they're still waiting for the proceedings to take place, in order for the employer to get judgment against the member and to be able to deduct what is due to him, they can also, consider getting an admission of liability from the member. Tando, do you also want to comment on that?
Well, of course, although, Julia, you would be hard-pressed to find admission of liability for somebody who's already in court defending a claim against you. But obviously, however long the process takes, if you do not have those two things, you're not going to succeed in persuading the member this benefit to be reduced.
Thank you so much. There's a question from Tsepo Chilwane, and he's asking, can the fund withhold deduct a member's benefit if there's a loan due to the employer? Tsepo, is this a housing loan? What employer? Is this a study loan? Because there's the only deductions that are allowable in terms of section 37D may be only that particular deductions that are provided in section 37D may be deducted from the member's benefit. So if you're talking about a study loan, it's not anywhere in the Act. If you're talking about a housing guarantee that is provided for in section 19, subsection 5, then that can be deducted from the member's benefit. So I'm not sure what type of loan are you referring to? If you can just come back and specify, then we can have this discussion further. There's a comment from that.
Just to add to that, I think the trustee may be referring to that matter that involved Agani, I think, where the study loan was an issue. And I think the adjudicator went at lengths to quell and to allay fears that perhaps loans are deductible from pension benefits. But I don't know what happened because I couldn't obtain the judgment. And I must admit, I missed the press release that was explaining that issue. It may very well be, but I think it was sufficiently explained to people who had the press release and who read the trustee today. I think there's also an article there that deals with that case. I think the question may be directed to that. Otherwise, it is tried that student loans and all of those things are not deductible from pension benefits.
Tando, are you saying they are not or they are now deductible?
They are not, Julia.
Okay.
You may not deduct.
Sorry, I was just like, oh, okay. So and I just need to add that Tsepo, there will be a session on section 37D deductions, and the presenter will touch more on this and the type of loans that can be deductible from, or the type of deductions that can be taken from the member's benefit. So then please attend that session. There's a comment from Naheem Esop, and he says that In my reading of the Smith case, the wife did not seek to enforce the settlement agreement. Instead, she was seeking an order for disclosure of information. Tando, do you want to comment?
You got cut there, Julia. Can you just say again?
Oh, Naheem is saying in my reading of the Smith case, the wife did not seek to enforce the settlement agreement. Instead, she was seeking an order for disclosure of information.
An order for what?
Disclosure of information.
Okay, no. Naim is right. Remember, the wife, for the wife to know what 50%, the wife had two prayers. In order to know what 50% of the benefit was, she had to know what the benefit was in terms of rands. So she sought two things. One, she sought to get disclosure of that amount so that she can assert her claim against the member, knowing the figures. Because subsequent to the divorce, I think the member got extra benefits that had pushed the benefit higher. So the wife said in order for her to exercise the right as to 50%, she has to be told how much is in the kitty. And the husband resisted that. But then the court said, for administration of justice, there is no way that the wife would punch in the dark and claim 50% of nothing. It has to be disclosed, and on both prayers, she succeeded.
All right, thank you so much, Tando. Naheem is saying you guys can chat offline.
Maybe we can.
There's a question from Yolanda Magengenen, and she's saying, I see withholding of benefits is permissible if the rules of the fund provide so. Now, is there any guidance within the legal framework with regards to the rules that provide that a member, or that provides that members on resignation from the employer will only be entitled to their withdrawal benefits after a certain waiting period of, for example, 6 months? These rules seem unfair as the fund withholds a member's benefit even without any claims from the employer.
Sorry, Julia, I'm not sure if it's my load shedding or if it's your connection. It keeps cutting because I needed to hear the full question.
I'm not sure if Sanchia, you're able to unmute Yolanda.
Or if you can, if you can unmute Yolanda, then we can have a discussion.
Sanchia?
Hi, Julia. If Yolanda could raise her hand, it'll be easier for me to find her to unmute.
There she is.
Thank you, Sanchia. Good afternoon, colleagues. So I'll just read my question for you, Tando. I was saying, I see withholding of benefits is permissible if the rules of the fund provide so, right? Now, is there any guidance within the legal framework with regards to rules that provide that members on resignation from the employer will only be entitled to their withdrawal benefit after a certain waiting period of, for example, 6 months? So for me, these rules seem unfair as the fund withholds the members' benefits even without any claims from the employer. Thank you.
Okay, thanks, Yolanda. I think I got the gist of the question. My understanding is that you under the rules, obviously the rules of the fund will complement the act that makes provision for reduction, right? And that makes provision for withholding. But then if you say you build it in your rules in anticipation of a claim that may arise against the member, so that you put him in a waiting period, if I'm construing the question correctly. Perhaps you want to come in, maybe I'm misconstruing the question.
Sorry, I think.
Hello.
Hi, Tando. It's Takalani.
Yes, thank you.
Yes, I think most of the waiting periods that we find, and I actually think it was raised in one of our training sessions last week. are in relation to industry funds where they believe that the likelihood of a member finding employment in the same industry and thus joining the fund again is quite high. So what they do is they will put a 3-month sort of waiting period in terms of paying you. And if you rejoin or if you get employment again in the same industry, then they just merge the record and it becomes, as if you basically didn't leave and, the 3-month is not there. So I'm thinking Yolanda's question, the only ones that I know of are either our sectoral determination funds, and I think for the ones that we have, they've removed that. But there are still some bargaining council funds that have that waiting period purely because they really believe that in terms of movement in the industry, most of the members end up joining the fund again quite quickly. I think there was a comment about it last week, but it was in relation to what happens now that we've got this paid up status, right? And wouldn't that actually overlap with the 3-month or the 6-month waiting period? Because now, a member might think they are in a waiting period and then the fund then makes you paid up. And that was the first time that I'd actually had to think about it in that light. But Yolanda's question, I think would definitely relate to those funds where they do have a waiting period, but they do it because they believe you're going to join again. So I don't know if you would want to address that in the same, it's not necessarily reduction, but it might just be that you address whether it's allowed, or there's nothing in the act that says you can have a waiting period in terms of payments. I think that's what Yolanda is asking.
All right. Thanks, Taki. And I must admit, I remember the question. I think it was Gerald who asked the question, and I fluffed it up a bit because I did not quite understand it. And sometimes your best answers happen after the conference. So I think I thought about that, and thanks for raising it, Taki, in line with what Yolanda is asking. First of all, a trigger event for the payment of a benefit, what makes the benefit payable, what makes it accrue to you by law, is what is stipulated in the rules, which will include the resignation, retirement, death, and all of those things. That vests the right because it triggers the event that is a condition on which the benefit becomes payable to you, obviously subject to the rules. So if the rules, in my view, personal view, if the rules are for a rational purpose, like you're outlining, that because there's high traffic in the industry, people come in and go in and go out, and you want to avoid administrative nightmares of people, member today, no member tomorrow, member not member today, and then you put a waiting period that says there must be this period that must lapse before we can pay you because you may very well come back. I think there's a rational purpose for that, and I think there's the time period must be proportional to what the member or the fund wants to achieve, which is if 3 months is deemed to be reasonable, then it is proportional to what the member the fund is trying to arrest. And I think what the question Gerald had asked last time was whether or not those were paid up benefits. And I had missed the nuance there. But my understanding is that paid up benefits have a specific definition, and they presuppose a change in employment, not the resignation. Because once you resign, the trigger event is that you are now due and payable to you, subject to, of course, that 3 months period. But that's not a paid up benefit in my view, at least not under the divorce regulations. So coming to Yolanda's question, I don't think in my view it would be permissible to have a presumption of guilt of theft for every member, and you say will not pay your fund until 3 months later, lest you have stolen from the employer, if that's what I understood the question to be. So that waiting period, that is anticipating a mechanism for the employer to be able to enforce claims against members who have stolen. In my view, I think it's an irrational proposition that there will be a presumption against everybody of having stolen until 3 months later. Then we know that you have not stolen. Then you are fine. Then you can get your benefit. I hope I've gone somewhere in clarifying what I think was Yolanda's question. I may not have had it correctly, and apologies if I answered something that you didn't actually ask. Thanks, Julia.
Thank you so much, Tando. We can take the conversation offline. I see that we are over time. Thank you for such an insightful presentation and for the questions.
We got 6 minutes, Julia, don't we?
No, I received a message from Sanchia, unfortunately. So
Nice.
Thank you so
It's
much.
just getting warmed up.
Yes,
Okay.
but for anyone who wants to ask questions, they can use the chat box and we'll just respond. Thank you so much. Over to you, Sanchia.
Okay, thank you, madam. And thank you, colleagues, and thank you, trustees. Thanks for the questions. Cheers, bye.
Thank you, Tando and Julia, for that thought-provoking session. We will now move over to the second session. Good morning, everyone. For those of you who don't know me, my name is Sanchia Petrie, and I am an analyst in the Fund Governance and Trustee Conduct Department at the FSCA. Today, I will be presenting on minimum benefits. So these are the contents of my presentation. We will do an introduction, which is just a background on minimum benefits, and then we'll look at minimum individual reserve and minimum pension increase. Now, what is a minimum benefit? A minimum benefit is a benefit payable upon the member's withdrawal from the fund prior to the member reaching retirement age. So this is a member withdrawing before they reach retirement age. So prior to 7 December 2001, there were essentially 3 problems in respect of the payment of withdrawal benefits. Now, why 7 December 2001? Because that is when legislation changed. So what were the problems prior to that? The first problem was in respect of defined benefit funds. Now, in defined benefit funds, members never received the actuarial reserve value when they withdrew from the fund prior to reaching retirement age. Members only generally received their member contributions together with interest when they resigned. Now, the only time when members received the full actuarial reserve value was upon retirement, not when they withdrew from the fund. The second problem, this is in respect of defined contribution funds. So what would happen is members would either receive no withdrawal benefit at all, or the member would receive their member contributions plus interest. So in some funds, though, depending on the number of years of service that was completed, the member would then sometimes receive a percentage of the employer's contribution as well. Now, the reason for the difference in these payments is because the employer ultimately had the discretion to pay the withdrawal benefits. So the employer decided if they would or would not even pay these withdrawal benefits. The third problem, and it was the concept of withdrawal profits. So here, when members left without their actuarial reserve value, the fund would add it to the surplus or distribute it as investment returns to existing members. So what normally happens is the remaining members, oftentimes executives, then benefited from this withdrawal profit. And this was at the expense of exiting members, which were normally your poorer members. So these are the main problems that the legislature sought to address, and this is what ultimately pushed legislation on minimum benefits. So the Pension Fund Second Amendment Act 39 of 2001, also referred to as the Second Amendment Act, came into effect on 7 December 2001. With the enactment of the Second Amendment Act, the legislation provided for minimum benefits, hence the introduction of the minimum individual reserve. Now, Section 14A, read with Section 14B of the Pension Funds Act, were introduced by the Second Amendment Act, and this brought to an end the payment of differential benefits by funds based on the circumstances of the member's termination prior to retirement. This be it registration, resignation, dismissal, retrenchment, or liquidation. The minimum benefit requirements override anything to the contrary contained in the rules of a fund. Section 14A and 14B of the Pension Funds Act. In respect of defined benefit funds, the legislation provided that members in defined benefit funds must be entitled to their actuarial reserve value. Now, what is the actuarial reserve value? It is the present value of the expected future benefits payable to a member upon retirement, which is determined by a formula set out in the rules of the fund and based on the member's earning history, age, and past service. Now, in a defined contribution fund, the minimum benefit legislation provides that members are entitled to the full members' contribution and employers' contribution, plus investment returns, less admin costs, and risk premiums. Now, just to reiterate, the commencement date refers to the date that the Second Amendment Act came to effect, which was the 7th of December 2001. Now, Section 14A 2A of the Pension Funds Act provides that the minimum benefits legislation shall apply immediately to any retirement funds that were registered 3 months after the commencement date. So 3 months after the 7th of December 2001 will be the 7th of March 2002. In respect of retirement funds registered before the 7th of March 2002, the prescribed minimum benefits must be provided for by the fund to in-service members 12 months after the surplus apportionment date for a member who ceases to be a member of the fund prior to retirement, and upon the liquidation or conversion of a retirement fund in the event that such liquidation or conversion takes place after the 7th of December 2001. Now here we're talking about the surplus apportionment date, and that refers to the first statutory actuarial valuation date following the commencement date of 7 December 2001. Now let's look at minimum individual reserve. In terms of Section 14A of the Pension Funds Act, the minimum individual reserve of a member must be determined as a capital value. Now, Section 15B of the Pension Funds Act also makes provision for minimum benefit top-ups for those members who withdrew from the fund prior to reaching retirement age before the fund's surplus apportionment date and who received benefits lower than what would have been the minimum individual reserves had the minimum benefit provisions of the Pension Funds Act been applicable to them. Now, Section 14B of the Pension Funds Act provides for the capital value determination of the minimum individual reserve of a member. So in relation to a member of a defined benefit fund, the board shall determine the greater of the fair value equivalent of the present value of the member's accrued deferred pension and an amount equal to the value of the member's contribution minus expenses increase or decrease by net investment returns. So it'll be the greater of these two. In relation to a member of a defined contribution fund, the board shall determine the value of the member's individual account. So this will be the member's contribution plus employer contribution minus expenses plus previous fund credit plus any amount lawfully permitted. And then it'll be this member's individual account plus a share of the investment reserve account, the member's surplus account, and such contingency reserve accounts as the board may determine should be included. Now, in relation to a pensioner or a deferred pensioner, Section 14B(6) of the Pension Funds Act provides that the board shall determine the fair value equivalent of the present value of the pension or deferred pension, adjusted for any minimum pension increase, including the present value of any contingent pension payable to the member's spouse, children, or other dependents. Now we'll have a look at minimum pension increase. So Section 14B of the Pension Funds Act provides for certain minimum pension increases to be granted by a pension fund to pensioners and deferred pensioners at least once every 3 years. And it requires each fund to establish a pension increase policy with effect from the commencement date, which is 7 December 2001. Now, every pension fund registered prior to the 7 March 2002, which is the 3 months after the 7 December 2001, must implement the minimum pension increase from the effective date of the first actuarial valuation of the fund that occurs after the commencement of the Second Amendment Act, which came into effect on 7 December 2001. So, the FSCA issued Interpretation Note 1 of 2010 to provide clarity on the application of the minimum pension increase in terms of the Pension Funds Act. Interpretation Note 1 of 2010 provides that a fund must at least once every 3 years perform a minimum pension increase test. Now, such test is usually performed as part of an actuarial valuation, and the effective date of the test coincides with the effective date of performing the valuation. Interpretation Note 1 of 2010 also provides that the fund must establish and implement a pension increase policy that aims to award pension increases in line with the percentage of the consumer price index or some other measure of price inflation which is deemed suitable by the board. Now, the FSCA issued Interpretation Note 1 of 2012 to provide clarity with regards to the obligation of a fund in setting and complying with its pensions increase policy. The fund must be able to justify why, despite its published pension increase policy, it was unable to comply with that policy in any particular year. And the fund must also take reasonable steps to ensure that appropriate policies are complied with. And that brings me to the end of my presentation. Thank you. I apologize for going through the presentation so fast. I am currently sitting with a power outage and was just scared that I might lose this workshop during, during the events. So we will be taking questions now, and my moderator Takalani Lukhaimane is also here, but we are also joined by Karabo Mufome, who is the manager of the actuarial department at the FSCA.
I don't think we're going to have many questions, Sanchia, although you ran, I don't want to say ran through it, but although you actually you feel like you went through it quite quickly, it was quite understandable. I think it was a nice short module, but I see Patrick has got his hand up, Motlokwa. Perhaps you could unmute him for us to hear his question.
Hi, good morning, everyone. Thanks for the opportunity. Yeah, I just want to find out the annual increase that is normally on the provident fund. Let's say maybe this year I'm contributing 800 rands, and then next year then it goes up to 850. How is that the percentage determined? Who determines the percentage? Is it the administrator, or is there a fixed interest across the board for all provident funds from the FSCA? Thank you.
Thank you for the question. Usually your contribution, especially in your defined contribution funds, is based on a percentage of your of a salary. So it's a pensionable salary. And usually, although everyone will complain about perhaps that increase is not as high as they'd want it to be, there's usually an increase to that pensionable salary year on year. So as the salary increases, that percentage might remain the same, as 7.5. But because your salary is increased, it means that that percentage would then basically in rand terms have gotten bigger. So that is definitely between yourselves or the employer and the employee in terms of the increase. It's not up to the fund, although the fund can speak to the employer and also motivate perhaps for increases based on costs that it might be experiencing, based on risk benefits perhaps getting higher, and so maybe an increase in the contribution is necessary. But the contribution payment is between the member and the employer in your defined contribution funds, as well as to a degree in your defined benefit funds as well, although there's a formula that you're using at the end. But so the percentage will increase as your salary increases, or the rand value in any event will increase as your salary increases, but the percentage might have stayed the same. I hope that answers the question. Was that from Patrick Motlokwa? Sanchia, I'm not able to see, or let me just quickly check who else had their hand up. I see Patrick's hand is still up, but Morgan Mtembu, I think it is, has his hand up as well. Perhaps you could unmute him for him to ask his question.
I have unmuted Morgan's mic. If you could, I've enabled it. If you could please unmute yourself.
Years of pensionable service, and if that is allowed, is the employer obliged to match the contributions?
Sorry, if you could just repeat your question. I think I started it right in the middle. And you might have started talking just before. Yeah, if you could just repeat your question.
As an employer, would you be allowed to buy back years of pensionable service? That is the first part. The second part, if that is allowed, then is the employer obliged to match the contributions?
Okay, so in terms of buying back years of service, I do know there are some funds that will do that. I suppose a good example might be the Government Employees Pension Fund. So when you join their fund together with contributions that you would have accumulated in another fund, they will then use that value to buy years of service from you, or to give you years of service. And there are some funds that do that. I think I just saw rules the other day where members were buying service in a DB fund with money that were transferring in. Is the employer obliged to match a contribution? No, they are not obliged to match your contribution. Again, that is something that is determined between the employer and the member in terms of your contract of employment. So no, they are not obliged to, but it just in most instances has become almost a you contribute half and I contribute half. But in actual fact, in most funds, it's the employer's contribution is actually usually a little bit higher, but it's not in all funds, but you're not obliged to match the contribution of the member. Do we have any other questions? Morgan Tembu, yes.
On the second part of the employer contribution, I just rejoined.
Oh, sorry, I was saying the employer doesn't need to match a member's contribution.
Thank you.
Thank you. Yes, Kara, would you like to add?
I just want to point out Jeremy Andrews' comment on the side chat. I'm not sure if you are able to see it or not. He was just referring to the definition of minimum benefit for a DB fund to say that your ARV actual reserve value, when you actually determine that, it's from the valuator's perspective to determine the liabilities, taking your resident benefit expectation, meaning that at the point of retirement, what you will reasonably be expected to get as a pension from that fund. When you look at your minimum benefit, it's when you do that using the prescribed assumption that we do publish on our website on a monthly basis. So when you do your test about your minimum benefit that the fund has to pay out, it should not be lesser than that. So the rules of the fund can actually stipulate any other greater benefit, but it cannot be lesser than the minimum benefit that the Act actually stipulated. As you said, Sanchia, in your presentation, Section 14B of the Act actually outlines how this is actually calculated. But it is correct for him to say that the assumption that the valuator uses when they determine your minimum benefit is actually prescribed by us and not necessarily your ARV. Oh, I'm sorry, I'm so used to saying ARV and it might be taken as medication and not actual reserve value. But yeah,
okay,
yes,
Karo.
thank you.
All right, thank you very much for clarifying that, and thank you, Jeremy, for your comment in the chat and clarifying that point. Thank you very much. Morgan, is that an old hand, or Mr. Mtembu, is that a new hand? New question? Okay, then I think, Sanchia, we don't have any more questions. Thank you very much for tackling thank you for tackling such a complicated subject as well. As soon as Karabo started talking, I was already worried that I might not understand what he's going to say. But thank you very much, Sanchia, for breaking it down for us so easily. Then I think without any more questions, we would be ready to move on to the next one. Sanchia, I'm going to hand back over to you.
Thank you, Taki and Karabo, for that session. I will now be handing over to Wilmi, and she will be sharing her slides for us. And in the event that I do go offline, Tando Mbono will take over as facilitator. Thank you.
Morning, everyone. I am sharing my screen. I hope you can see. If I can just have a few thumbs up to confirm that you are able to see. Okay, I've never shared in presentation mode, and now I have lost my Teams screen. Oh goodness. Let's see. Okay, there it is. Sorry, everyone. Good morning. I am Wilmi van der Walt. I am in the Retirement Funds Conduct Supervision Department, and I will be taking you through the effect of divorce and maintenance orders on pension funds. I must say that this is a topic that hasn't come across my desk a lot, or even at all, in my years at the regulator. I think it's a topic that is more dealt with, on fund level, board level, administrator side. Yeah. So my presentation will cover the legislative framework and relevant definitions that's contained in the relevant legislation, the effect of a divorce order, Islamic marriages, applicable time periods, maintenance orders, and lastly, the hierarchy when we look at maintenance versus divorce orders. Okay, so in terms of the Pension Funds Act, the general rule in terms of Section 37A is that pension benefits are protected from deductions. However, the Divorce Act provides for one exception to the general rule, and it contains a definition of pension interests, which opens the door for pension benefits to be deductible by a non-member spouse upon divorce. So the definition of pension interest in terms of the Divorce Act has two parts. Part A of the definition relates to a member of a pension or a provident fund, and Part B of the definition relates to a member of a retirement annuity fund. I did not include the full definition in my slides. I find that definitions contained in legislation is quite long, and yeah, so you can go read up on the specific definition of pension interest. It is important to note that the Pension Funds Act also provides for a definition of a non-member spouse, in that a non-member spouse may claim a percentage of the active member's pension interest upon divorce. So when we look at the definition of a non-member spouse, in terms of the Pension Funds Act, is defined as a person who is no longer the spouse of that member due to the dissolution or confirmation of the dissolution of the relationship by a court order, and to whom the court ordering or confirming the dissolution of the relationship has granted a share of the member's pension interest in the fund. It is important to note that upon divorce, only the non-member spouse will be entitled to elect either to receive the pension interest as payment or have it transferred to another retirement fund. The member is not entitled to his or her benefit upon divorce. When we look at a divorce order, there's a principle that comes into play, namely the clean break principle. So prior to September 2007, a non-member spouse had to wait until the pension benefit accrued to the member before he or she could claim a percentage thereof. Section 37D introduced the clean break principle in that it provides for the portion of the benefit awarded to the non-member spouse upon divorce accrues to the non-member spouse on the date on which the decree of the divorce is granted. The deduction will be made in terms of a divorce order, which was granted in terms of Section 7(8) of the Divorce Act, or any court order made in respect of the division of assets of a marriage under customary law. It is also important to note the clean break principle has also been extended to state funds by separate amendments to the respective acts of Parliament. So we can ask, what if a non-member spouse failed to claim his or her share of a member's pension interest during divorce proceedings? The Supreme Court of Appeal in the Ndaba matter held that failure by a spouse to seek an order awarding him or her a portion of the member's pension interest should not preclude the non-member spouse from claiming a portion of the member's pension interest after a decree of divorce has been granted. And will interest be payable on a non-member share? A non-member spouse is now entitled to fund return from the date that his or her share of pension interest is deducted upon instruction to the respective retirement fund until it is either transferred or paid. When we look at Islamic marriages, the adjudicator in as early as 2012 was of the view that the meaning of spouse in the Marriage Act was wide enough to accommodate Muslim marriages. Our courts have only recently forced a change in law to recognize Islamic marriages as valid under the Marriage and the Divorce Act. The FSCA, in President of the Republic versus the Women's Legal Center Trust, declared the Divorce Act unconstitutional insofar as it failed to provide for spouses in Islamic marriages to claim pension interest, and the FSCA ordered that all unions validly concluded in terms of Sharia law and in existence on the date of the judgment, which was handed down in 2021, or which were terminated in terms of Sharia law, but whose legal proceedings were still pending and not finalized on the date of the order, may be dissolved in accordance with the Divorce Act, and all the provisions of the Divorce Act would be applicable. Section 37D has or includes certain timeframes that run upon submission by the non-member spouse of a decree of divorce to the member's retirement fund. When a divorce order, which has been granted in terms of Section 7(8) of the Divorce Act, is submitted to a respective fund, that fund must, within 45 days, request instruction from the non-member spouse as to whether his or her share of pension interest must be paid directly to him or her or be transferred to another fund. Within 120 days from being requested to make an election, the non-member spouse must advise if he or she is taking cash or provide the details of the fund to which the money must be transferred. The fund must then, within 60 days of that election by the non-member spouse, action the request by the non-member spouse. If the non-member spouse fails to make an election within the 120 days, the fund must pay the benefit directly to the non-member spouse within 30 days of the expiry of the 120 days. And should the fund not be able to ascertain details as to payment or transfer of the non-member share, the fund may retain the non-member share until such details are provided. When we look at maintenance orders, Section 37 capital D provides for deductions from a member's pension benefit or minimum individual reserve. It's important to note the pension benefit or the minimum individual reserve of an amount in accordance with the maintenance order, either granted by the High or Magistrates Court in terms of the Maintenance Act. Normally, retirement funds are ordered to deduct arrear maintenance from the member's fund credit, but orders for future maintenance may also be paid by retirement funds. Although the Pension Funds Act specifically permits judicial attachment of retirement benefits to satisfy maintenance claims, attempts to attach these benefits fail due to failure of the maintenance order to name the correct retirement fund, the failure to cite any retirement fund to which a debtor is a member, or for requesting a withholding of benefits due to a member, the court order being too vague to be enforced, and an order of court referring to incorrect defined terms. So it's very important that when maintenance orders are made, an order of court or are drafted, that specific information be captured on the order for it to be enforced. So when we look at what comes first, Section 37D(3)(b) of the Pension Funds Act provides for which order a decree of divorce or a maintenance order gets preference when it comes to payment. Where a pension fund receives simultaneously a maintenance order and a decree of divorce, or an order for the dissolution of a customary marriage and an Islamic marriage, the maintenance order takes preference over the decree of divorce or order for the dissolution of a customary or Islamic marriage. And in terms of Section 37D3A of the Pension Funds Act, loans or guarantees granted prior to a decree of divorce or a maintenance order enjoy preference. So first, the fund would pay a loan or guarantee. Secondly, a maintenance order. And thirdly, a decree of divorce. That was my story, ladies and gentlemen. Any questions? Tebogo, I didn't see any questions in the chat box, or perhaps I missed it while I was going through my presentation. Did you notice any questions for us?
No, Wilmi, no questions up to so far on the chat box. I'm also looking at them, so I don't see any questions that have been posted currently.
Yes, I see a hand. Sanchia,
Yes.
Will you assist? Thank you.
Sorry, Wilmi, I think Sanchia might have fallen off. She did say that she has a battery problem.
Yes, and I think it's load shedding as well on her side. She did indicate that.
Yeah, it might be that she's no longer with us, and I'm battling to find whose hand it is because I haven't done this. I'm at a loss.
Wait, Tando, I found the correct button. So, Mr. Aimon, I have allowed your mic. Please proceed with your question.
Okay. Good afternoon, trustees, and good afternoon, presenter. What I need to find out, in the event that the divorce order that the fund receives and that divorce order is just silent, is that the fund responsibility, or is that the fund obliged to find out from both the member and the non-member if that is enforceable to the fund or is not enforceable to the fund, or the fund can just presume that it's not enforceable and just make payment to the member to the fund if the member of the fund is claiming the benefits? Thank you.
Thank you for your question. Tebogo, can I have a go at it, or would you like to answer the question?
You can have a go, Wilmi, then I'll see if I can add anything on that.
Okay. So when we look at the definition of a non-member spouse, the emphasis I added on the slide that should be on your screen is the share of the member's pension interest that should be paid to the non-member spouse should be specified in the court order. I would say that if the court order is silent on pension interest or the non-member share, that might follow later if there's a claim on the member's pension benefit. Tebogo, I don't know if you would want to add something, or Tando.
Yeah, with what I've seen in most when you do on-site, Wilmi, especially when you ask that question, is that in most cases it has to be an order that is issued that the member spouse is entitled to 50%. So I haven't seen an instance where nothing was pasted on the court order, and I'm not sure whether funds will go back to check with the with a member or the non-member spouse to check whether they are intent on claiming 50% from the member.
Thanks, Tebogo. I think it's important for the court order to contain, you know, the share that the fund must act on. Without the court order, you know, requiring any action from the pension fund, I think it's going to be difficult for the pension fund to act without the court order setting out what they need to do.
Yeah. I will also presume that, you know, from what I've garnered when I do on-site is that you get attorneys from both sides. I think those are the first question that will ask the member or the non-member spouse to check whether they do have pension funds and whether they would like to claim from them. So I think I'm not sure what would have been the, you know, the issue with regards to them not having that being part of the court order, or it might be that maybe one or two of them or both of them didn't you know, allude to the fact that they do have that and they'd like to claim from the other members you know, pension fund.
Thank you, Tebogo. I did see a hand, but it was lowered. I can't remember who put it up. Any other questions?
Wilmi?
Yes.
Yeah, I think I see questions on the chat box here. Okay, the first one I think is from Evelyn. What is the position on customary marriages dissolving? I think you've covered that. Can you maybe also just go through it and just cover that quickly?
Yes. So as I stated that you know, marriages in terms of customary law and in terms of Sharia law, you know, will also, you know, you can also claim pension interest when a marriage in terms of customary law was dissolved.
Thank you, Wilmi. And I see another question here from Dave Alloc. For divorce orders granted prior to 2007, distribution to the non-member spouse only to be made at time of withdrawal or retirement of the member. Can this now be paid before this event now that the regime has changed? I think you've covered that, Wilmi. I think it can be done. It can be paid before.
Yes. I think I did cover it. I didn't go into detail, but the short answer would be yes.
Okay. The other question relates to the housing loan guarantee. It says, does the loan have to be paid before the non-member spouse receive the benefit? I think it's the hierarchy that I think you dealt with at the end of the presentation, Wilmi. Where you make provision for
Yes.
the housing loan will be paid first, and the maintenance order will be paid second, and the divorce will be the divorce order will be made. That will be the last one to be taken.
Yes. Tebogo, you are correct. Sorry, it's just my bell in the background. I apologize. As previously indicated, the topic on the other deductions, specifically housing loans, there will also be a session on those deductions.
I see a statement here from Mr. Sakihead that the major challenge to fund in respect of divorce orders is poorly worded settlement agreements that are made orders of the court. And to be enforceable, the order must comply with all the minimum requirements. Only the parties can approach the court to amend the agreement. The fund cannot. Okay, that's
Yes.
a statement from Saki. Yes, yeah.
Yes, Saki, that is correct. That is a big problem. You know, that the necessary information isn't contained in the settlement agreements or on the order, so it makes it difficult to comply with the requirements. We agree.
Yeah. Okay. The other question is it imperative that the divorce order states the name of the fund? I think it will be, because I think it will make things easier for the non-member spouse to be able to claim from the member's pension fund, because without that it create a problem. So I think I'm currently sitting with a you know with a query where a non-member spouse had to call our office to say, look, this is what I have. I don't have the the proper information regarding the fund, and you know the non-member spouse was questioning us to assist with giving information on the fund that the member might be belonging to. I see Tando's got his hand up.
Yes, thanks, Tebogo. If I may just add, as I recall it, I think the Act says the fund must be named, or at least it must be identifiable from the order if it's not specifically named. I think it's a specific requirement of the provision. Thank you.
Yes, Tando, you are correct. It's a specific requirement in terms of the Act.
Yeah, Wilmi, I don't think there are any more questions. I think these are just statements that are just, people are just putting in here. So another statement from Ben is, often the member and spouse automatically assume that 50% is payable on divorce. In that case, a settlement order should be requested from the parties. Yes, that's yeah, we agree with that. Okay, and Gloria states, I agree with Wilmi that the court order must clearly specify what is claimed from the fund. If it is not clear, the member may amend the court order to be specific as long as what is claimed was in the prayers of the divorce. Yeah, I think we don't have any more questions, Wilmi, from the chat box. Unless there are any other questions, unless there are any other questions from the floor that we can take before we close. Going once, going twice.
Thanks, Tebogo. I think it's safe to say we are off the hook. Thank you, ladies and gentlemen. Thanks, Tando.
Thank you, Wilmi, and thank you, Tebogo. We're indebted to you. Truly very kind of for you to agree to be one of the speakers and moderator in our workshop. I think it brings us to the end of our program, because I see our Sanchia has fallen off because of the battery. It brings us to the end of the program for today, and hoping to see you bright and early tomorrow, I think at about 9 for further topics. All that remains for me is to thank everybody's participation and the attendance. It's really very encouraging, and the participation. Have a good day. Cheers, colleagues.
Thank you. Bye.
Thank you.
Bye.